thank you so much to the conference organizers for inviting me to give this presentation on the impact of state and federal laws on healthcare practice generally, with a particular emphasis on laws that relate to providers' conscientious beliefs. So I'll begin by speaking about the ways, begin by setting my timer. I'll begin by speaking about the ways in which medical practice is regulated in the United States generally, with a particular focus on laws that either compel or prohibit conduct by healthcare providers. Next, I will describe the state and federal conscience regulations that protect providers from adverse action when they decline to participate specifically in abortion. And finally, I'll conclude with my thoughts on the future of abortion laws after the Supreme Court's decision in Dobbs versus Jackson Women's Health. So as healthcare providers in this audience and attorneys know, medicine is regulated primarily at the state's level. So the state's authority to regulate medicine is grounded in the state's 10th Amendment unenumerated powers to protect the health, safety, and welfare of their citizens. So statutes, administrative regulations, and common law or judge-made law all play a role here. And here's just one example of an early Supreme Court opinion explaining the basis for state regulation of medical practice under its police powers. So the most foundational laws at the state level are medical practice acts that grant individuals the authority to practice medicine. These laws establish the requirements for professional licensure, the scope of permissible practice, and the grounds on which boards can discipline physicians or revoke their licenses. The entity responsible for enforcing these laws is a state administrative agency called the State Medical Board. Now, while the structure of these boards varies from state to state, the majority of their members are physicians, at least for the medical boards that control physicians. And so in this sense, medicine is a self-regulating profession. The state legislature grants authority to a board composed primarily of physicians, and those physicians then enact more specific regulations that guide the practice of their peers. So many have criticized state medical boards as an example of regulatory capture, where a government entity is dominated by members of the industry that is being regulated. And there's certainly a historical basis for this criticism. So the first medical licensing laws enacted in the United States were actively promoted by medical professional associations in an effort to legitimize the practice of medicine, to grant greater status to licensed physicians, and to limit the economic benefits that could be secured by non-physicians. And these early licensing laws were specifically drafted to exclude providers like midwives, homeopaths, and what at the time were called irregular practitioners. And these concerns about regulatory capture in the healthcare professions continue today, from scope of practice laws, challenges in that area, as well as a recent Supreme Court decision criticizing the North Carolina Board of Dental Examiners, so this is the professional board regulating dentists in North Carolina, challenging them for taking action against non-dentists who provided teeth whitening services. So once a provider is licensed by the state, the boundaries of their day-to-day practice are set primarily by customary professional practice, more so than any specific legal standards. And the legal doctrine that you're probably all most familiar with is the common law doctrine of medical malpractice. So physicians and other healthcare providers can be civilly liable to injured patients if they breached the standard of care and if that breach caused an injury. Now, what constitutes a breach of duty in any particular case is generally determined by judges and juries based on testimony from medical experts. And so these experts are responsible for informing courts about what the professional standard of care is. And I will note that this term standard of care has a very specific legal meaning that may differ from the meaning that healthcare practitioners ascribe to it. Legally, a healthcare provider has complied with the standard of care if they acted in a way that reasonable practitioners would deem medically appropriate in a given context. And obviously, there may be many different legitimate approaches to diagnosing and treating a particular condition, and all of those may fall within the legal standard of care. The takeaway here, though, is that the legal standard of care in medical malpractice cases is effectively set by the medical profession itself, because it's all related to customary practices that are demonstrated through expert testimony. And I'll offer one additional note about the judge-made law relating to medical practice. So a doctor's duty to comply with the standard of care only kicks in once they have an established treatment relationship with a patient. So unless that treatment relationship has already been formed, a doctor doesn't owe any individual person a legally binding duty to treat. And this is in contrast to a federal law, EMTALA, that I'll speak about in a moment. Now, obviously, state laws do restrict doctors' ability to discriminate against patients on the basis of race, gender, religion, etc. But if a patient approaches a doctor requesting a particular treatment, that doctor is not legally obligated to take that person on as a patient, nor are they obligated to provide the requested treatment. So in that sense, doctors have a great freedom under state law to define the scope of their own practice. So a dermatologist is not going to be required to perform orthopedic surgery, and more relevant to our situation, an OBGYN can establish a practice where they provide contraception, prenatal and postnatal care, and labor and delivery services, but set a limitation that they won't provide abortion services. And as I'll speak about in a few moments, providers have even greater protections as a result of federal and state conscience laws. Finally, there are some areas of medical practice where legislatures have stepped in to override the common law doctrine that's based on customary medical practice. And this typically happens in contexts that are politically controversial, like reproductive care. So for example, some states create specific language that doctors have to use when they're counseling patients about abortion. Others require pharmacies to have emergency contraception in stock and dispense it to anyone who's authorized to receive it. In the end-of-life care context, all states have advance directives and power of attorney laws that specify what happens when a patient or a surrogate requests withdrawal of life-sustaining treatment. In some states that have authorized physician aid in dying, state laws establish the procedures that doctors need to follow in order to provide life-ending medication. And one of the more recent controversies regarding legislative interference in medical practice is legislation that prohibits physicians from offering gender-affirming therapy to children. There's many other examples of situations where state laws have been passed to either prohibit or compel doctors to practice in a particular way. And when doctors violate these laws, they may be liable civilly to injured patients, they may be subject to criminal penalties or discipline by state medical boards. So in these areas of medical practice where legislatures have directly stepped in to establish standards, some healthcare providers may face conflicts between their own beliefs about what is medically appropriate and what the state requires or prohibits. So for example, in states where abortion is legal, doctors who hold religious or conscientious beliefs opposing abortion may object to performing them. And their objections are protected both by the common law I mentioned earlier, limiting obligatory duties to treat, as well as the conscience laws I'll talk about in a moment. In the context of gender-affirming therapy, in contrast, some doctors have argued that their ethical beliefs about the appropriate standard of practice compels them to provide these services, even in states that prohibit them. And in end-of-life care contexts, doctors are legally required to comply with requests for withdrawal of life-sustaining treatment. Not all providers may feel comfortable doing so. And on the flip side, some providers may be unwilling to provide aggressive end-of-life interventions, even when patients or families request them. Now, I'll note here that typically when we talk about conscience in medicine, we most often talk about providers who, based on their conscientious beliefs, object to participating in certain procedures, and abortion is the most common example. But when we consider state laws relating to medical practice, it's relatively rare for laws to affirmatively and unequivocally require a doctor to provide a specific service, right? Much more often, we see laws prohibiting certain types of medical care. So abortion after the 3rd trimester, aid in dying, excessive prescription of opioids, et cetera. And so in those situations, as the previous panel spoke about, doctors who are willing to provide those legally prohibited services are expressing their affirmative rights of conscience, the right to provide services that the law otherwise prohibits. It's rarer to find situations where doctors are actually compelled by law to engage in actions that they may oppose on grounds of conscience. And the most prominent example, and one that I've explored in my research, are abortion-informed consent laws that require doctors performing abortion services to communicate specific information to patients seeking abortion, to provide ultrasounds, to require that patients view those ultrasounds, et cetera, regardless of whether the doctor thinks these disclosures are medically appropriate. And in these situations, a doctor's conscience, or their beliefs about the ethical practice of medicine, right, acknowledging conflicts about what we mean by conscience, may motivate them to refuse these requirements. That said, in most situations where conscience is exercised by healthcare providers, we see conscientious refusals to perform a service that is legally permitted but not required. There are, of course, federal laws that regulate medicine, but they're often more focused on institutions than individual providers, and they often deal with broader issues that don't necessarily implicate day-to-day medical practice. So Congress has the authority to pass these laws by virtue of the federal government's taxing and spending powers, as well as its power to regulate interstate commerce. Now, because about 36% of healthcare spending in the United States is by the federal government, because 90% of primary care physicians accept Medicare, and almost all hospitals do, right? This means that those who accept that federal funding are then obligated to comply with thousands of federal laws and regulations that relate to Medicare and Medicaid. So the federal government's conditions of participation for Medicare and Medicaid are particularly important. That said, these laws primarily set high-level operational standards rather than direct guidance about how to practice medicine. And then there are plenty of laws that you've probably heard of that apply more broadly, not just in the context of governmental payment, like HIPAA, the Health Insurance Portability and Accountability Act, which focuses on the privacy and security of healthcare information, the HITECH Act, which focuses on information technology, interoperability, et cetera. Then we have a few laws that are focused more directly on the quality of care, like the Healthcare Quality Improvement Act and the Patient Safety Quality Improvement Act. Both of these laws are aimed at strengthening internal peer review processes within hospitals, encouraging reporting of adverse events and medical errors, and establishing institutional policies for addressing medical errors. Of course, we've also got laws regulating drugs, devices, which implicate prescribing practices. And then finally, we have EMTALA, which I'll talk about more in just a moment. So the Emergency Medical Treatment Act, an Active Labor Act, requires hospitals that participate in Medicare to screen patients who present at their emergency departments, to screen them for emergency medical conditions. And if an emergency medical condition is found, the hospitals are then required to provide appropriate stabilizing treatment before transferring the patient elsewhere. So this law was actually passed not to secure any quality of care standards, but it was passed in the 80s to prohibit the practice of patient dumping, where private hospitals, when they saw emergency patients who were uninsured or who had public insurance, would just transfer those to public hospitals in order to protect their own economic well-being. So the takeaway here is that although there are lots of federal, state laws and bodies of judicial doctrine that govern the practice of medicine, few of them impose concrete legal requirements to deliver specific services to specific patients. So most commonly, these laws require doctors to comply with the standard of care as set by the medical profession itself, or they prohibit doctors from engaging in services that legislators believe are inappropriate. So this brings me to another way that state and federal legislatures have stepped in to direct the practice of medicine. Right? So this conference about conscience in medicine centers on the ethical conflict that arises when a doctor's deeply held beliefs conflict with expectations about how medicine should be practiced, right? And so sometimes these expectations are set by the public or by patients. Sometimes they're set by actual laws defining the standard of care, but as I noted earlier, it is relatively rare for laws to affirmatively define the context of the standard of care. So I'll begin with a quick overview of federal laws, and then move on to state laws relating conscience, which have a greater impact, in my opinion. So the first federal conscience law was passed shortly after the Supreme Court's 1973 decision in Roe versus Wade. So the Church Amendment protects hospitals and individual healthcare providers from discrimination if they refuse to participate in abortion or in sterilization. And like the federal laws that I described earlier, the Church Amendment is grounded in the federal government's spending powers. So what it does specifically is it protects recipients of federal funding from government interference. And this includes hospitals, medical schools, residency programs, and research institutions. It's also one of the few conscience laws that protects providers from discrimination if they affirmatively choose to provide abortions. So in subsequent years, a number of other federal laws and regulations were passed protecting primarily negative rights of conscience, the right to refuse participation in abortion. And these apply in various contexts, from medical students, medical schools, hospitals, insurance plans, et cetera. And so you probably recall the recent, well, not so recent anymore, conflict after the passage of the Affordable Care Act regarding health insurers' obligation to provide insurance for contraceptive care. So these federal conscience laws are enforced by the Department of Health and Human Services Office of Civil Rights. So anyone who violates these conscience laws is potentially subject to loss of federal funding and further investigation by the Department of Justice. Now, in 2019, under the Trump administration, HHS issued a final rule called Protecting Statutory Rights of Conscience in Healthcare. And that rule strengthened the Office of Civil Rights, OCR's enforcement authority. So under this new rule, OCR would not be limited to responding to complaints. Rather, the rule granted OCR affirmative authority to review compliance and to investigate on its own accord. It also expanded the definition of certain terms like healthcare entity, referral, et cetera, which broadened the scope of protections offered by conscience laws. Now, this rule is no longer in force since courts in New York and California and Washington have found that it was invalid. So right now, it's unclear how active HHS is going to be in responding to complaints about violations of conscience laws. One area where more recently HHS has delivered direct guidance is on the intersection between federal conscience laws and EMTALA, the Emergency Medical Treatment and Active Labor Act, which I mentioned earlier. This past July, just a few weeks after the Supreme Court handed down its decision in Dobbs, HHS issued a notice clarifying that EMTALA applies to all emergency medical conditions, including those that are pregnancy-related. EMTALA, as I mentioned earlier, requires the provision of appropriate stabilizing treatment for medical conditions, and when there's an emergency condition that is pregnancy-related, like, for example, an ectopic pregnancy, some complications relating to miscarriage, severe preeclampsia, the appropriate treatment the standard of care treatment for physicians may be pregnancy termination. So this HHS guidance explicitly states that because EMTALA is a federal statute, it preempts any and all state laws that criminalize abortion in this narrow context of emergency medical treatment. So in other words, if the appropriate stabilizing treatment for a pregnancy-related emergency condition is abortion, EMTALA requires hospitals to provide that service, even if it is criminalized otherwise under state law. Now, I'll note that this HHS guidance is currently under review by courts. In late August, a federal district court in Texas temporarily enjoined the enforcement of this new guidance in the state of Texas. And in Idaho, a federal court is considering whether the state's near-total abortion ban conflicts with EMTALA, grounded on statutory language about the definition of emergency in the state's law. So while these federal conscience laws are certainly important, as a practical matter, state laws have a greater impact on healthcare providers. So I conducted a study of state laws through the end of 2019. I'm in the process of updating it, so please bear with me. As of that time, 47 states had conscience laws that specifically referenced abortion, and 46 of those protected refusal to provide abortion. I'll also note that there is one state, Mississippi, that protects conscientious refusal in the context of all healthcare services, but did not specifically reference abortion. And earlier in our presentations, one of the commentators had mentioned the general lack of protections for affirmative rights of conscience to perform abortion. There are 6 of these states that protect abortion refusals also provide some affirmative protections in the context of employment for providers who offer abortion services, but that would not impact their criminal liability. And then we also have Vermont, which does not have a refusal law, but does have a conscience law for affirmative provision of abortion. So most of these laws, like federal law, were passed to protect physicians who were not willing to provide abortion services. But in recent years, these state laws have expanded to a significant degree. So first, some apply to refusal of services beyond abortion. So they may protect refusal to provide contraception, emergency contraception, in vitro fertilization, research on human stem cells, or aid in dying. So the scope of services has been expanded in many states. Secondly, most of these states extend these laws beyond protecting the providers who directly perform abortions. So some protect all healthcare providers, some protect, quote, all persons, and many impact healthcare institutions like hospitals, protecting them, which obviously has a greater impact on patient access in rural areas. These laws also extend beyond the direct provision of abortion and protect involvement that is potentially more tangential, but that might nevertheless be considered complicity in an immoral act by someone who is claiming conscience. So protected conduct under these laws may include providing referrals, or rather refusing to provide referrals, to transfer prescriptions, to provide transportation, to provide translation services for a patient seeking an abortion, etc. So once we've determined who is protected and for what kinds of actions, what exactly do these laws do? So there's a wide variety of consequences that refusing providers might face if they are not willing to provide abortions. And this can include civil liability to injured patients, criminal prosecution, adverse action by employers, adverse action by state medical boards, among others. And so in the study that I conducted of state abortion refusal laws, I found that 37 states established civil immunity for refusing providers. So in other words, if a healthcare provider is unwilling to provide an abortion for reasons of conscience, and that refusal violates the standard of care, which is only going to apply in a limited set of contexts, like pregnancy-related emergencies, and a patient is injured, that patient no longer has a legal right to recovery as they would under the traditional law of malpractice. And then finally, I'll note that some states may offer patient protective limitations on providers' rights of conscience. So for example, some states, few, may require that providers who exercise their right of conscientious refusal nevertheless have an obligation to provide information about abortion, provide a referral, or inform their employers of the refusal. Some state laws also limit situations in which the right of refusal can be exercised. So for example, in cases of emergency. So these patient protective limitations, however, are not common. So about just over half of states that protect conscientious refusal to provide abortion don't include any of these patients' protective limitations. And as I'll speak to in just a moment, the scope of all of these protections becomes even more important after Dobbs. So this brings me to the final part of my presentation. The Supreme Court's opinion in Dobbs versus Jackson Women's Health overturned Roe versus Wade, and in turn has shifted decisions about the regulation of abortion to state legislators. So in Dobbs, the Supreme Court held that the 14th Amendment's substantive due process liberty interest does not protect a patient's right to choose abortion in conjunction with their healthcare provider. That matter, according to the court, is appropriately left to state regulation. And according to recent reports, states are taking a variety of approaches to regulating abortion. So some, like my home state of Illinois, are establishing themselves as safe havens for patients seeking abortion. Others, like Texas, had existing laws from decades ago that criminalized abortion that were triggered and put into effect by the Supreme Court's decision. And other states, like West Virginia, pretty quickly passed legislation restricting abortion. Of course, there are several states, primarily controlled by Republican legislators, that are still struggling to decide how to approach this issue. So in Indiana, for example, where senators had campaigned as pro-life advocates, they're now grappling with the question of how to translate their opposition to abortion into real-world policies. Should there be exceptions, for example? And that is why I think it's critically important to examine the future of state conscience laws after Dobbs. Because when states implement restrictions on abortion, direct restrictions, those laws are immediately in the public eye. Legislators are going to face questions, they're going to face challenges. But another way that states can meaningfully impact access to abortion services, either increasing it or restricting it, is by amending the conscience laws that they already have. And although these laws have a huge impact on abortion access, they are not in the public eye, right? Most people in the American public are focused on direct prohibitions and criminalization. So obviously the future here is still unclear, but I'd like to offer a few preliminary thoughts on the likely impact that Dobbs will have on the state conscience laws that I've described. So first, in states that choose to prohibit all abortions that impose criminal, civil, or administrative penalties on providers who perform abortions, existing conscience laws are effectively going to become redundant, right? Providers and hospitals that oppose abortion aren't going to need to advocate for any changes to the conscience laws. Those laws will simply become irrelevant in light of the complete prohibition. And for the same reason, reproductive rights advocates who want to protect patient access are going to have to challenge the abortion laws themselves. Conscience laws are no longer relevant. In conservative states that prohibit most but not all abortions, and here we're going to see a lot of that, right? Abortion prohibition except for emergencies, except for rape or incest. In those states, let's imagine a state that has a prohibition on abortion after 6 weeks. So in that state, a doctor who is not willing to prescribe medication abortion in the earliest stages of pregnancy is still going to need to rely on the state conscience laws to protect themselves from adverse action. And the same would apply to a provider in a state that prohibits abortion except in the case of rape or incest. A refusing physician or hospital would still need to rely on the state conscience law to protect themselves. And in these states, refusing providers are going to want to expand the scope of their conscience laws. And it's likely that those expansions, which I'll talk about in just a moment, in Republican-controlled states will be successful. And so the same situation is going to lie in progressive states that offer greater protections, except in those states, we'll have reproductive rights advocates pushing to narrow the scope of the state's conscience laws in a variety of ways. So, finally, what kinds of changes to state conscience laws are pro-choice and anti-choice advocates likely to advocate in the face of Dobbs? So here I'm going to turn back to the various ways in which state conscience laws differ, and I'll highlight the areas where legislators have the flexibility to either expand or contract conscience protections. So first, looking at the scope of providers who are protected. Supporters of conscience rights are likely to review the laws in their states carefully to ensure that the broadest scope of providers are protected, not just physicians, but all healthcare providers, perhaps all persons, all hospitals, right? In contrast, pro-choice advocates are likely to limit the scope of protections as much as possible. And in Democratic-controlled states, I think there's a possibility of succeeding, particularly with respect to narrowing the scope of protections to physicians who directly provide abortion services and to religiously affiliated institutions, right? Protecting those narrow categories of individuals and entities from adverse action relating to conscientious refusal. So in these states, legislators that have broad conscience laws may try to limit them and, for example, say, okay, these conscience laws don't apply to secular hospitals, only religious hospitals. These conscience laws don't apply to nurses and physician assistants and medical technicians, only doctors. And so another area where I see possible legislative action is in the type of conduct that is prohibited. So as I mentioned earlier, there's a broad scope of activities that may be viewed to be connected to abortion, from a pharmacist dispensing medication to a physician's assistant taking a patient's blood pressure. So conscience advocates may try to expand the definition of assistance and participation in their state laws. On the other hand, pro-choice advocates will try to limit conscience protections to direct performance of abortion. The next area, and I think this one is really quite important, is in terms of health and safety exceptions. So of the 46 states I mentioned earlier that protect conscientious refusal to provide abortion, only 13 currently limit that right of refusal in cases of emergency or medical necessity. Obviously, now that HHS has issued its guidance on EMTALA, a federal emergency exception effectively exists nationwide, though there's some uncertainty as to how that will play out as this regulation goes through the courts. Where I think there's potential for meaningful movement at the state level is in progressive states that want to ensure freedom of access. So legislators in these states could expand their conscience laws to limit providers' right of refusal in a broader variety of circumstances related to medical need, right? So not just immediate medical emergency as described in EMTALA, but also if a pregnancy poses a risk of future harm, right? Or if a pregnancy is likely to exacerbate a patient's mental illness. And so progressive legislators could frame this as a natural extension of the concept that the federal government proposed in EMTALA, right? That medical necessity, albeit broadly defined, is not a situation where providers should have a right to exercise conscientious refusal. Here, conscience advocates in conservative states don't have much opportunity for movement here, right? If a state already has an emergency exception, they could eliminate it, but that would ultimately be preempted by the federal emergency law. Next, let's look at patient protective conditions on the exercise of conscience. While few states, as I mentioned earlier, currently have them, there are lots of gatekeeping possibilities that could be put in place to protect patient access when providers refuse. So just a few examples. First, requiring providers to offer complete and accurate medical information about the medically appropriate options that are available to them, including abortion, right? And so this can come into play in situations where patients have health conditions that might be aggravated by pregnancy, but who aren't aware that termination is an option. Currently, only one state, Illinois, requires full informed consent to disclose abortion and the details of abortion as a medical option. Secondly, progressive states might require refusing providers to either refer patients to facilities that are willing to perform abortions, or at least provide general information about how to access these services, like a hotline or a website. So only 2 states, Illinois and Georgia, require this. And then whether these conditions are going to be expanded more broadly across the United States are likely to depend on the political orientation of the states. So historically, states have been hesitant to impose referral requirements because of arguments that requiring a doctor provide a referral makes that doctor complicit, morally complicit in abortion. On the other hand, several professional medical association ethics committees, including the AMA and the American College of Obstetrics and Gynecology, have suggested that medical practitioners have an ethical obligation to provide information about abortion and how to access it. So my guess is that Democratic states that want to affirmatively protect abortion will move to expand these information and referral requirements. And then finally, I know I'm running out of time. As I described earlier, I know that these laws vary significantly in the procedural protections that they offer, right? So what adverse consequences are providers protected from if they refuse to participate? So states that are more protective of abortion will want to narrow the scope of procedural protections available to refusing providers. So they could, for example, maintain protections for general discrimination against refusing providers while allowing employers or medical boards, for example, to take action against providers who are violating institutional policies or professional guidelines. They could also eliminate civil immunity provisions so that patients who are injured by a provider's conscientious refusal would at least retain their right to seek compensation for their injuries. Or, as I've previously argued, states could follow the lead of other anti-discrimination laws like the Civil Rights Act and the Americans with Disabilities Act and limit rights of refusal in situations where that would pose a direct threat or where it would impose an undue hardship on the employer. So in conclusion, in the aftermath of the Dobbs decision, both states that want to limit abortion access and those that want to expand abortion access have a variety of options for strengthening their positions using state conscience laws. By amending these laws to either expand or contract protections for objecting healthcare providers, these states can significantly impact patient access to abortion services in ways that are less visible to the public and therefore less likely to draw public criticism. Thank you.